Legally Speaking with me, Tarun Nangia. Today we take up a very, very important issue, that is law and economics, the interplay between law and economics, and of course, linking it to the mineral sector. As we know, India has one of the largest reserves of coal, iron ore, and many other minerals. And also we see that many times that these reserves are many times under forests in places where we have problems extracting them. How does India, in a sense, match its needs for growth at 6 and 7% with also the needs of conserving the environment? Both can't be ignored, but both are important. 2-3 cases that we will bring up today. One, of course, the recent find of lithium in the state of Jammu, where I think mining was banned until recently. I don't know when Goa what happened some time back, where iron ore mining was banned. A copper plant was shut down in Tuticorin, which overnight turned India from, in a sense, net exporter of copper to importing copper, and we lost foreign exchange. So all these things we're going to take up today. I have a very, very interesting panel, a mix of people from the judicial side, from the policy side, from the social side, who do work on environment and social issues. May I welcome Justice Arjun Kumar Sikri. Sir is one of India's leading and most busiest arbitrators. He is thankful to him that he shared time with us today. Of course, he's also the judge at the Singapore International Commercial Court, and previously has also served as the Judge of the Supreme Court of India. Good to see you again, sir, and looking forward to some interesting insights from you. I have with me Ma'am Aruna Sharma. As you all know, ma'am most famously served as Secretary, Ministry of Steel, Government of India. She also served as Secretary, Ministry of Communications and IT. Recently was also member on the RBI Committee of Digitization of Payments, and now is a board member with various companies. Good to see you, ma'am, and looking forward to some interesting insights. I have with me Pradeep Mehta, Secretary General, Consumer Unity and Trust Society International. They also author many exhaustive and important reports on Indian environment and other issues. Good to see you, Mr. Mehta, and looking forward to some insights based on the reports that you have authored. I think that would prove useful for the viewer. At the outset, may I request Aruna Sharma, ma'am, to just in about 2-3 minutes, if you could share with us what you've seen, because you are on the policy side there, how this interplay happens between law and economics, because you make policy, people go to court sometimes objecting. How does this work?
Yes, it's a very, very serious phenomena which is emerging here. And consciously, I'm using the word serious because on one hand, the Forest Conservation Act 1980, which came, emerged as a very strong watchdog at the high-tech speed. One was moving towards mining, especially the mining industry or construction industry and everything. And we have the incidents of Joshimath, and we had some incidents in Kudremukh in the past. But having said that, it is equally important that this act is more like a watchdog, but it should not become like an impediment into the whole thing. And when you talk about the law, we do have incidents with us, what you mentioned now, finding lithium in Jammu and Kashmir, and it is said to be one of the largest deposits in the world, much more than China. On one hand, when we are talking about the electric vehicle, then the young Himalayas and mining in young Himalayas is going to be an issue. So there has to be a correct balance in case we want to extract lithium from there, which is very, very important for the economy of the country, vis-a-vis ensuring that we follow the norms of the environment clearances. The same principles had applied in Goa, where it was not at all an environment issue, but it was filed, the case was filed in the name of environment. It was the sort of making the two acts talk to each other, and ultimately, finally, it settled to auction, which again took very long time. The resultant was the state with highest per capita income became one of the lowest per capita income. The state which was never indebted became a debted state, 5,000 crores of debt it is having on debt. And now that after a long gap, 2018 till date, when finally the auction has taken place, it is the same players which have come forward. And to open a mine, they have to restart their businesses. So we have that example in front of us. Then, of course, there was a Supreme Court judgment, and pardon me, Justice Sikri, where what you call it is a common cause judgment, where the illegal mining definition was not very clear. And what was not illegal, for which they had applied, all these miners have applied and they were in process. There was a delay in the sanction. They were paying the royalties of whatever they were extracting, but suddenly it was declared to be illegal by the court, and there was a very, very heavy fine. The big players could pay the fine. The small players became NPA, went to NCLT, and then they have to be literally bailed out. Otherwise, they would have been completely out of the business. So with these initial remarks, what is more important is that on one hand, we definitely want watchdogs to ensure that one is conscious about the environment and the damage done to the environment. But on other hand, it is very important that today we extract only 10% of the minerals what nature has gifted us. And that can be a major source for economic development, and especially that area development, which is in forests, of tribals, poor people, and it can add to the economy of the state and a better development. So that correct balance, very delicate balance, is the issue.
Point well taken. And also, I would like to point the recent case of Vedanta's copper plant in Tuticorin. Before it shutting down, it accounted for production of 40% of all of India's copper. When it shut down, we turned an importer of the mineral. Earlier, of course, we were exporting. We are a net exporter. So I think with one decision, you can completely change the fortunes of a country. But we'll go to Justice Sikri at this point. I would like to famously refer to, I think, your most, what I would say is oft cited judgment of Shiv Shakti sugar mills, where you had quoted that interface between law and economics is much more relevant in today's time, when the country has ushered into an era of economic liberalization. The judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in this direction. It called for economic analysis of law approach, commonly referred to as law and economics. And I think this is one of the most crucial paragraphs from that judgment, where you explained this whole concept. When the judicial wing is deciding these things, what all you go into, because you also have to consider the country's growth on one side and also these issues, how difficult it is, because for example, lithium or the Goa mining or the Vedanta copper plant, all these issues are on law on one side, on economics on the other side. How is that balanced? How should that be balanced?
I think, and if I may say so in the beginning, that Madam Aruna Sharma, as well as you, have already set the pace or set the tone of what the debate should be and what should be the focus, even when the courts have to decide the matters. And as Arunaji very rightly mentioned, it's that balance which has to be maintained. Crucial balance, the development of the nation on the one hand, and the judicial review of certain decisions which are taken on the other hand. If I may start, and I would say in the beginning itself that it is that maintaining that delicate balance is the challenge. And in particular cases and in given cases, whether judiciary has been able to maintain or not, criticism comes when judiciary falters in that. And you, both of you have given the examples of a few cases in this behalf. Now, on the one hand, as I said earlier, there is a power given to the courts, particularly high courts and Supreme Court. High courts under 226, Supreme Court under 32, and even in appeal also they can, when they hear the cases from the decisions of the High Court. This is power, what we call power of judicial review. Now, this power is given under the Constitution. So the constitutional courts, as High Courts and Supreme Court they are called, they have the power of judicial review, and power of judicial review extends to any action taken by the executive, that whether the action is right or wrong. I'll come to the, on what grounds the action can be perceived as right or wrong. But not only the executive action, even the laws passed by the legislature, whether it is the state legislature or it is the parliament, if the law is unconstitutional, it can be challenged, and the power, unlike United Kingdom, where the courts don't have power to strike down any legislation passed by the parliament as right or wrong, because this is parliament is supreme and parliament has passed the order. But in India, we say that it is the constitution which is supreme, and any law made by the parliament or the state legislature, if it is unconstitutional and the court finds that it is offending any provisions of the constitution, any fundamental rights, etc., or the law made is not within the powers of the legislature, then it can be declared unconstitutional. So very wide powers are given when we say it is a power of judicial review over administrative, executive, or even legislative action. Having said so, and now coming to the executive action in this behalf, the power, again, the Supreme Court has very clearly stated, and there are a number of judgments, law is very clear on this, that while undertaking that exercise, the courts cannot go into the merits of a decision, a policy decision, which is taken by the executive and the government. The court cannot say that, look, there could have been a better policy decision on the merits. No. But on the due process, and as I said, whether such a decision is constitutional or not, or whether it was authorized by the government or the body which passed that order, so those kinds of limited grounds are available. Now, this is the power of judicial review. Coming to the issue at hand, and when we talk of, as we are talking of the environment on the one hand and extracting of minerals, etc., which may be good for the growth of the nation. Now, here again, there are the principles which are laid down internationally, which are accepted by the Indian courts and widely accepted by everybody, even the government and the legislature has accepted, that the most fundamental principle which we talk is of sustainable development. And everything has to be looked into from that prism. That, yes, on the one hand, we have to have the development of the nation, which is required, and which as you have quoted, I said in Shiv Shakti judgment also. On the other hand, we have to protect the environment as well. So therefore, development should be there, but it should be sustainable. We have to maintain the ecology and maintain the environmental, it should not lead to adverse consequence on environment or climate change, etc. And there are certain principles which are apart from the sustainable development. We say polluters pay principle, that if the polluters, the particular industry which is set up, it has polluted, they are bound to pay. We have the principle which is called intergenerational integrity, etc. That, look, when we talk of environment, it is not that we are thinking of our generation only. Because this is the environment we are giving to our successive generation, and we have to look for them also. There's another principle called precautionary principle. As per that, if the courts would look into that and would err on that precaution, we have to take precaution. Now, these are the principles which, on the one hand, say that environment is to be given due importance. On the other hand, as I said, principle of sustainable development recognizes the fact that that doesn't mean at the cost of, for the sake of environment solely, we ignore the development. Yes. So therefore, here what Arunaji said, the question of balancing comes. And of course, these principles are there. There are so many judgments which are stated, and including the judgment which you mentioned about Justice Gawai, who has given along with I think this is Vikram Nath, that judgment which has been given, and 118 projects which were pending for last 4 or 5 years, they were stuck. They have all been given a go ahead, and a green signal has been given. And let me tell you here that way back in 1994, that was a case of this Airtel. No, it was a tender matter, Tata Cellular. Okay. In Tata Cellular, Supreme Court said that when the projects are conceived by the government and the tenders are awarded, etc., and if they are challenged before the court should be very slow in granting the stays and halting those projects because of so many reasons. Number one, delay will escalate the cost. Number two, if the tender is already awarded and the contractor has come on the field and the court grants a stay, then it is going tomorrow that contractor will file the case against the government for that my labor was idle, my machinery was idle, etc. And therefore the unnecessary burden on the government. And as arbitrator, I have been doing so many cases like this. So therefore, the court said in Tata Cellular, which has been repeated in many cases, and in that Shiv Shakti, again, I had repeated this quoting Tata Cellular. So therefore, principles are there. There's no doubt about it. Now, question comes, how to apply this principle in a particular case, how to maintain that balance. And as I said earlier, and my preliminary comments would be that it's a challenge to the judiciary. Judiciary has to see that while balancing has to weigh that whether public, and here I'm not talking of environment and not talking because at interim stage, when the stays are granted and it is going to have these kinds of repercussions, that whether on the one hand, it is, project is of such nature that it should not be given a green signal and it should not go ahead at all, because the consequences on the face of it are so serious that it would be at the cost of humanity or environment, etc. But at initial stage, having such a kind of assessment would be difficult, and therefore the question is at that the courts have to keep in mind that if the things are such that ultimately, like I said, we have polluter pay principle also, that even if the project ultimately, the petitioner is able to show that, yes, it is causing some damage, but that damage can be repaired and polluters pay, that person would have to pay, then why grant that stay? Because if suppose after 2 years or 3 years, if ultimately the writ petition is dismissed, then who will pay for that cost, that escalation, etc., which may be in thousands of crores? You can't ask that neither the person who has filed a writ petition would have capacity, nor you can ask him to pay that cost. So, but the country or the economy would suffer. So therefore, in given cases, in every case, there is a challenge. And let me tell you one thing more here. There is a tendency, and we have seen many times, because of course there can be two ways of challenging such things. Number one is person, suppose tender was issued and contract is awarded, a person who is not awarded the contract, whose tender is rejected, comes and files on certain grounds that this should have been awarded to me. Other is no, in the form of public interest litigation, some so-called public spirited person comes and he says that, look, this kind of project should not be allowed to go ahead because it is going to affect the environment, or may have some kind of repercussions of other nature. Here we have to be very clear, because what is seen, and if I may say, the PIL was originally conceived as a good idea, a noble idea, that those persons who are poor, those persons who are illiterate, are not able to access justice, and because of their poverty or because of their illiteracy. So locus standi concept was enlarged, that some public spirited person can come and file on their behalf. So for the marginalized sections of society, it was done. Of course, environment, thereafter, the second stage come when the environmental issues also were included. And the third stage, where there is a lot of debate whether it is proper or not, in the under the name of good governance, when even the policy issues, many times the courts, Supreme Court or High Court, would interfere. For whether this third part is proper or not, there is a debate. But having said so, what I'm saying is there may be some cases, even on the aspect of governance, those may be good cases in order to ensure that the governance is not going wrong. And some of the actions of the executive may be totally faulted. But taking advantage, we know that many frivolous PILs are also filed. many persons would come and they would have other motives. I mean, many times the court says that while dismissing that it is public, not public interest, publicity interest litigation, one person wants publicity. But publicity may be one thing. But if the litigation is filed for, some such PIL is filed for other ulterior motives, and it may be of many kinds. It may be, look, when you said that we are, a country who wants now economic progress, we want to be 5 trillion economy in next 2 years or so. So there may be some, players outside India who may not want it.
Yes.
And we do not know whether some PILs are engineered at the instance of such persons.
Yes.
We do not. So therefore, but here, challenge is for the judiciary to discern, to separate this wheat from the chaff, so grain from the chaff, and that is where, if sometimes or in such important issues, if the court falters on that, it may come with heavy cost.
Very, very, very beautifully put all this issue and shared. And in fact, when we read the Shiv Shakti Sugar Mill judgment, also we get hints of how you arrive at a certain conclusion of things. That's very beautiful. I'll go across to Pradeep Mehta from Cuts. In fact, I would like to take this forward with two things. One, what Justice Sikri also shared, that 118 projects stuck for 5 and 10 years cleared by Justice Bhushan and Justice Vikram Nath. Secondly, too, in Goa, due to COVID, people didn't have tourism jobs. Mining was stopped. So lakhs of people were jobless. In Tuticorin, when the copper plant shut, 2,500 crores as taxes could not be collected by the government. 5,000 people directly lost jobs and 25,000 indirectly. So do you think that in between there was this whole bogey that some neighboring nation could be involved in all this in India, because we just continue to export natural resources. We don't manufacture finished products. As we can see, we turned a net importer of copper. Do you see a design to all of these things? Because I think you understand this better than us, all this which happens. Could you share your insights into this?
I'm sure I will, but I only hope that you had balanced all the speakers.
Yes.
I think your time is up. I don't know whether you still wanted to speak.
No.
You have time?
Yes, we do.
Right. Having heard both the speakers at length, let me make some very broad remarks to begin with. One is that development often does, go against environment, and you can't stop that. And if you look at we've done a lot of grassroots surveys where people have said that, pehle pet, uske baad phir vatavaran. You must understand this very clearly, that what is the common person's thinking about many of these issues. When you mentioned the Tuticorin case, Tutukudi, it's not a mining case, by the way. It was a smelter which apparently was supposed to be polluted. But the whole issue was so badly handled by the State Pollution Control Board, the Tamil Nadu government, and the Supreme Court as well. It's really pitiable. And we did this study after the Shiv Shakti sugar case. I must tell you, we did 5 studies for Niti Aayog after the Shiv Shakti sugar case to see whether there has been any impact in the thinking of both the Supreme Court and the National Green Tribunal. Unfortunately, Justice Sikri, I'm sorry to say, zilch, zero. That was the kind of, the kind of knowledge sharing, etc. We spoke to National Judicial Academy, etc. that, look, can we do something on this? And we always ended up with a wall because of too much of protocol and too much of bureaucracy surrounding most of our things. Now, having said that, one thing which I've often said is, if you look at agriculture, has been one of the biggest intrusions in environment from centuries, all because people need food. And therefore, you've been cutting down forests and growing food. So let's not forget that there are very clear examples as to why development often overtakes the environment. Now the issue here is basically how do we balance both of them? Justice Sikri spoke about sustainable development. And I'm again sorry to say Justice Sikri because a lot of our narrative has got sort of guided and sort of brainwashed by the Western thought. Sustainable development has three aspects: environment, equity, and economy. That is the definition of sustainable development. And you often slip into environment again and again without understanding that there are two other issues which are very important to understand in the context of sustainable development. I think this is a narrative which we need to build up to counter the narrative which we have grown up with. I've grown up with it, and then I've only understood it about 10 years ago that, look, this is what is happening. Many of the WTO disputes on environment versus fishing, for example, tuna dolphin case, example, was again taken on the grounds of sustainable development. And until you then analyze as to what sustainable development means, that you're only looking at environment. I mean, that is one of the exceptions provided in the GATT Article 20 as an exception, that you must understand that. Secondly, in the case of Tuticorin copper, for example, there was the matter was also gone to the National Green Tribunal. National Green Tribunal, which is headed by a retired Supreme Court judge, whose appeal only lies before the Supreme Court and not before any High Court, got a field visit conducted by experts. The report showed that, look, there was no pollution as such from the smelter. Yet the Supreme Court, did not bother about that particular finding, and instead of at least taking it as evidence on record, if not a legal opinion, in that sense that this is what is to be done. And there again, it erred very badly. Now, the other cases that we dealt with was including iron ore, the Goa iron ore case again. Again, as you rightly said, Tarun, in your opening remarks, there was some very clear design behind it, which was linked to the kind of what Arunaji spoke about, the kind of economic impact it had on Goa's economy was terrible. I mean, along with the Mopa airport, that was the third case that we took after this. Now, in the iron ore matter, we examined it again at very detailed. The petitioner had even suggested an alternate solution to it. That solution was not even looked into. It may not have been, there could have been a negotiation with the petitioner, which was a public interest body and a renowned body. It's not somebody which was sort of funded by to sort of go against our economic interests. Perhaps Tuticorin, there was some kind of foreign elements which did go against it. That is what we suspect, but there's no evidence that we can say that. And you're right. I mean, the country lost in it. And we hope, not only that, now there was a citizens' movement to restart the plant. Because, the very large number of jobs, is the data which you pointed out, it's all there in our record, including on our website, to look at it, just to look at what the kind of impact it had. Now, if you go back to the Goa iron ore, there again, the court did not get into the details of, I mean, there was, series of PILs, one after the other on that. And the state government mishandled it very badly. They did not put up the case very properly before the courts, with the result that, and the courts also did not, handle it properly also. The problem, Justice Sikri, is that none of the judges look at the totality as you did in the Shiv Shakti sugar case. And the important thing is that this is something which is a kind of a principle of law and economics which operates in the US judicial system very clearly and very effectively. And that is, again, we have quoted that in this thing.
No, they started way back in 1970s, 80s.
Exactly. Exactly. Right. Now, there are counter arguments to that as well, Justice Sikri, if you remember.
Yeah. There's a lot of debate.
No, one of the things which even Pinky Anand and you were debating in one particular television fora, and then Montek Singh Ahluwalia again said, look, you cannot allow discretion on the courts to do it. Now, we have said that, look, you don't have to do it. If the judges are not engineers or economists or cost accountants or whatever they are trained to be judicial officers. the Specific Relief Act also allows the courts to appoint a committee. You can appoint a committee, which has happened in many cases before the courts. Now, one ridiculous example I can give you again, Justice Sikri of Supreme Court. On road safety, another issue that we, and particularly on that liquor ban on the highways. And what courts do not do is to look at the implementability of their orders. Today I'm sitting with the National Green Tribunal order for pressure horns in Jaipur city. And there's no implementation, no enforcement. And I pleaded before the NGT, we have to address the root problem. Ban the damn pressure horns. Ban the manufacturing and the sale and the import. Otherwise, it continues to disturb it.
But I like that this sort of you beautifully juxtapose 3-4 different issues to get to the point.
Let me, Tarun, if you should be balanced. I mean, you should give me enough time as you gave the other speakers, or you should have cut the other speakers also. Yeah. And I'm the senior most here, by the way.
Please go.
Be aware of that, right? Now, in the R&O matter again, it is badly handled by the state government. We have said that very clearly. So you often have problems arising out of mishandling by various people, and it costs jobs. Therefore, the final argument that, Tarun, we have taken up in our own stand is that let us look at environment versus livelihoods.
Environment versus livelihoods.
Livelihoods. Now, we are looking at, you quoted so many figures, Tuticorin, iron ore. Thousands of jobs have been lost, both upstream and downstream, and not only in the main production activity. How do you deal with that? So where is it, as I said, to come back to the kind of the common perception is that, my stomach is more important than the environment. You have to look at it this way, and what you rightly said, and what has been said by the speakers before, is we have to balance it. But we are not saying that you can sacrifice environment. Now, going back to an important point, Arunaji, if you remember, one bauxite deposit in Odisha could never be mined because of the tribals, all the Niamgiri Hills, for example. Now, there are sentiments involved. So you can't allow the miner to go ahead and mine bauxite in a hill. So there could be similar issues. You have to provide for exceptions. I remember even in the past, power plants could not be located in places because they were going to encroach upon forests, etc. So there is a balance required. The proposal that we have already made before our judicial system is that, look, get things examined on the basis of cost and benefit, versus on the basis of environmental livelihoods, and then arrive at a decision. Use technical help. And these are you're allowed under the law. Other than the fact is Justice Sikri has quoted Article 142(1) of the Constitution of India, which is a very sweeping article. I mean, in a sense, a very positive article. Yet, there are a lot of lawyers who don't agree with that interpretation, because of the fact is that decision could lead to, how it happens in the Indian system. Often if you give discretion in the powers of judges or bureaucrats, there's a tendency to misuse it for extraneous reasons, as we know. So that is one argument that we have to look at. So therefore, we have suggested this, is that, look, set up a committee of experts to deal with a particular issue, and let that committee then come forward with this particular thing. Now, Tuticorin case, Justice Sikri, I could not understand as to why the Supreme Court did not respect the NGT's findings. I could not understand. There's a brother judge sitting there, if I may ask. Fine, you can't take it as evidence, at least take it as
You see, to tell you and interject at this stage, as far as committees and formation of expert committees are concerned, I think Supreme Court has been doing so.
Yeah, exactly.
Cases it has done.
No,
and
many
you are
cases.
right, not only in environment issues, other issues also, of course, and particularly when it comes to writ petitions under or 32 Supreme Court, obviously, because there is no evidence there, the parties don't have to, documentary evidence can be given, but no oral evidence, etc. And who is right, who is wrong? Normally, you're very right. Committees are to be appointed and expert committee can give. But yes, it may happen and most of the time these expert committees' views are respected as well. Maybe
I agree with you.
unfortunately in
No,
that case, it did not happen.
let me tell you of one case where we found a lot of disconnect. There is a Supreme Court committee on road safety sitting in Annex E Bhavan, costing the taxpayer a huge amount, headed by a retired judge and two bureaucrats, two
I know
Aruna
that.
Sharmas there.
Yes.
Or one Aruna Sharma and one somebody else. Friends of mine, Sanjay Mitra is now there, Sundar Yu was there, and so on. They had already made an opinion on the sale of liquor on highways. Can you imagine? The judgment which was passed did not refer to that particular advice at all.
Oh.
I was shocked. What the fudge is happening?
You
There is
see,
a clear...
if I may say in a lighter vein, environment issues are such, environment versus this growth. And as far as the Supreme Court or courts are concerned, I'm not defending. You are right. And as myself said, that many times this challenge which comes before the court to maintain that balance, they have not been able to do in certain cases. But there's a very good saying, and rightly so. I mean, this is the position in reality, that those who are for the development say that the Supreme Court or the High Courts or the NGT is unnecessarily interfering with the project. And those who are the environment activists, they say that the judiciary is not doing enough.
We have to see there is a clear need. What has been stated by both you and Arunaji,
doesn't mean that
there is a need for a balanced approach.
Individual cases which you have quoted, I agree with you that
I can quote you more. There's no time.
I think, Mr. Mehta, I'll have to get this discussion back on focus, because we could end up going on, I think, another for 20-25 minutes, but there is some limitation of time. I'll go across to Justice.
No, I'm happy. I made my points, except whatever points I had to make.
And beautifully so.
And you have taken much more time than all of us. Don't worry.
I'll go to Justice. Sir, you very interestingly brought two quick comments now, final. You very beautifully brought this point of how Justice Bhushan Gawai and Justice Vikram Nath cleared 118 projects stuck for 5 years, and many of them which are stuck for more than 10 years, which also means that sometimes big decisions can happen, which are even stuck in courts. Big decisions can happen. I think your Shiv Shakti Sugar Mill judgment is one such big decision, which I think I have myself in the past 7 years quoted many times in many of my shows. So do you think that when remedial measures can be taken on issues where, I remember on the car issue where you banned the diesel vehicles, you did not ban cars on the road. You said the most polluting car should be banned, and of course cars should continue. So you mean there are remedies to everything. Could you reflect on that for 2 minutes and then we can move ahead?
You see, let me tell you here, as Mr. Mehta has also pointed and Arunaji has also pointed out, and initially what I said was that, look, there may be some times and some of that Goa case, initial banning on the mines order was not because of environmental issues.
Yes.
So it was that the licenses were given, so the fault was found on administrative law grounds, correct? Now, there are many such cases, 2G case, and even coal cases, etc., where the licenses were given. It is found that there was not proper procedure, etc., followed. Now the question is, in these cases, and when these are the issues relating to economic development, on the other hand, what I feel is, yes, the courts have right to undertake judicial review on that ground, but when it comes to the giving relief, or what should be the ultimate direction or this. So there, I agree with Mr. Mehta. The courts can just tweak a bit, like in these cases, Goa cases and others, and even this 2G, etc., where persons had established their businesses. They had spent a lot of money, invested a lot of money into that. Now, just cancelling that and sending them out of business. And as Aruna said, that then those companies, particularly middle level company, going to NCLT and seeking rescue, instead of bringing that position, why not? Just you could have imposed some fine or some penalties, etc., and allow them to continue. That It's a technical.
That is the point. That is the point which we have also made, Justice.
Okay, so therefore, these are some of the things which can be done. And as Mr. Mehta has pointed out, Article 142. And so, particularly with Supreme Court, if that provision is there, why not utilize in these cases and in this manner?
Yeah.
That provision.
I think I would like to, because you're almost out of time, sir. What I'll do is I'd like to end with Ma'am Aruna Sharma. But before that, I think Mr. Pradeep Mehta, if for 1 minute you can make a comment, and then Ma'am Aruna Mehta can close the show.
No, I've already said what I had to say,
Yeah.
except that what is important is the Shiv Shakti sugar case has to be, amplified across all the courts possible. And I don't know how you're going to do it, Justice Sikri, but that is something
one way is which you have said, and it should be done because now we accept judicial training. So therefore, that is one good way of, in a way, creating awareness among judges that what approach should be there. You apply law. I have said in Shiv Shakti also, that doesn't mean that for the, in the interest of economy, even when the action is illegal, you uphold that. No way. You apply law, but then if there are two views possible, or there's another way out, like which I suggested just now, and where the economy of the country and the development, etc., can also be safeguarded simultaneously by adopting some other means. Why not do that? And therefore, that kind of, I think, because economics is one subject which many judges would not have even read it. So therefore, some kind of awareness, some kind of training is required on that.
My point. Now I'll take this to Ma'am Aruna Sharma. Ma'am, sitting in the Secretariat in the Ministry of Steel. I remember talking to you then also when you were Steel Secretary, and huge capacities in steel production were created in the country. Now you take initiatives there in the Secretariat, plants come up. Then some countries outside India who want to stall India's development mischievously use the PIL route to get projects stalled. We have seen this in India. Sometimes it may be frustrating for a bureaucrat also who's put in his heart and soul for this capacity to come up. Could you reflect on how a growing country should see all this? The mining issue, the copper plant issue. Now we have lithium in Jammu. Something may come up tomorrow, because I remember you told me once that there also even permissions in mining are not easy to come by in Jammu because of certain shrines that are present there.
Absolutely right. And here I will say the executive will also have to play a proactive role. Let me give you an example of Karnataka mining, where the Supreme Court has put a ceiling of how much should be mined. Now, what happens is this, what was mentioned by Mr. Mehta very rightly, the training of judiciary is very important on these aspects. Because with the technology change, it was said that it is harming the environment. Now with conveyor belts, with slurry pipelines, others, you're not affecting the environment at all. And these technologies are being adopted in a very big way. And at that time when everybody worked together, that is the industry, the executive, and when we filed a petition in the court to the committee, and we literally educated the committee, made state government also to talk the same language, then we could enhance the ceiling. And in future, we said that Supreme Court has got nothing to do in putting the ceiling. Let there be a committee of Ministry of Steel, Ministry of Mining, and maybe some environmentalist civil society into it, and then decide. Now, this is the kind of a line we will have to build in, that these committees, because many times executive also becomes a bit lazy in taking a proactive role. I've seen that happening. So they will also have to be activated and put the facts in place. And then sort of a balanced committee report can be taken up. And some of the lines where Supreme Court should not get into these decisions of what should be the ceiling, because we have seen it in what was mentioned by Justice Sikri about the coal cases. Now, suddenly cancelling all coal mines, all the investment, what you were talking about, of syngas was completely frustrating. Those plants were stand still till last year, when again coal was given. And the hilarious thing is today everybody is talking about the future lies in syngas way of operating, and that before the hydrogen gas comes. So in the sense, we have lost precious 4 to 5 years in between. It's gone. And okay, that particular industry could take a shock of their debt and could pay off their debts because of the way the industry started reviving. Otherwise, it would have been a nail in the coffin for them. So these kind of judgments are very important to pause instead of being in a hurry to put a ban. And that pause should go to the committee under Section 142, very rightly has been said. And in that committee, there has to be an open discussion. Give them a time of 15, 20 days, not tomorrow, file, 3 days. That kind of a thing sometimes becomes very difficult into the entire system. And that can be the guiding factor before we go. Because it is very important for us to generate the jobs, to absorb the new technology, to be conscious of the environment. The technologies should be encouraged, which makes, if I say about mining, the environment-friendly mining, if it is an infrastructure project, the project has to undergo all the watchdog cautions and then move ahead, because you must see that these are the things which are going to be in India, and economy in India will have to grow based on that. Every country builds on the USPs. Now, if we have a software USP, we are struggling the same problem. The somersaults of the policy makings, and then corrective courses in between every time you have to break.
Thank you so much. We are almost.
That's how it works.
I would have liked each of you to speak much more than this. My time doesn't permit at all, but I will look forward to inviting you on another show. And each of you, I know, will share much more of what you have done and what can be done. But I would like to thank Justice Arjun Kumar Sikri. His time is very precious. I'm really thankful that he could make time, knowing how busy he is with his arbitrations, and I can vouch for that. But we remind him, he was kind enough to share his time. Ma'am Aruna Sharma, thank you so much for sparing time. Pradeep Mehta of Cuts International, thank you so much for all the research and all the data points that you give us time and again. And of course, I appreciate all of you joining us, and maybe looking forward to more opportunities to talk to all three of you again. Appreciate your joining us. Thank you so very much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.